Hello everyone, this is Cheenu Sharma. Welcome to Jury's Journey, NCA Triumph and Canadian Law. So today we are going to take up demo lecture for professional responsibility subject. Next, this examination is scheduled in August. So I have already started a course on this. So today in this demo lecture, we will be discussing first two topics in short. So I am not going to provide complete lecture here because that I have already taken up in the course. So here I'll be sharing few parts from these two topics that I have covered in the course so that you can get an idea like how I am teaching in the course, what all you will be getting. So these two first topics, profession, professionalism, regulation of lawyers. Now let's begin. So in this lecture, we are going to cover two important first topics. So the number one is the legal profession, lawyers in society and society of lawyers. Being a part of legal field, one should understand what does word profession means under law. So this is the first topic. Next, lawyers in society. So we are a part of society. Being lawyers, we represent an important field. So how society expects us to be. What kind of relation you have to make with your clients. So whether your client accept loyalty, whether they accept some kind of trust. So all these things, what kind of society together we make in this legal field as a lawyer. So these things we are going to study in this first topic. So the issues to consider under this topic: what is profession, what is public interest, how people see you, so what they expect, role of lawyer and profession, legal process and society, law as a business, whether one should see law as a profit making thing or we have to serve society with this profession. So law as a profession, what is the difference? Are these two things conflicting? Must it be one or the other question? What is at stake in this discussion? Power, opportunity, responsibility of lawyers in society. Can lawyer dominate anyone? So what are the opportunities that you get being a lawyer? Like you get so much respect. This is the biggest opportunity I feel. Then what is the responsibility? What you have to give back to the society as a lawyer, what you have to give back to your clients? Legal ethics. So what all moral principles you have to take with yourself while you are into this profession? So you have to imbibe few things within yourself under your moral compass. So what are all those legal ethics? What is the orientation of lawyer's value framework? What role do values principle play in determining the obligation of lawyer? Loyalty, integrity, justice, these moral principles, these ethical codes, what does these mean? Where does these things stand? So lawyers obligation to themselves, they should be truthful, then to client, to court, to society. Is there any conflict between these duties of lawyer? So we will be studying that. Then lawyers are seen as moral or morally neutral actors. How much this statement is correct? Should personal honor, personal morality, extra play a role in lawyering process? What are the various arguments on either side of this question? What model code provision animate both sides? Is there a conflict? How should it be resolved? Whose morals are we talking about? So here when we are talking about ethics, morals, whose morals? Lawyers, clients, societies, or anybody else? So all these questions will be answered one by one under this lecture. So once we are familiar with profession, what is a legal profession? Is this a profit making? Is this a service? Then how a lawyer should be in the society, ethics, morals of a lawyer. Then we'll talk about how this lawyer thing, this legal profession is regulated. So is there any law society? Who controls? So the roles and responsibilities of law society in governance of legal profession, this we will be studying. What are their purpose? Are the purposes being achieved? What alternatives might be considered? How legal profession is structured? What kind of education you need? Is this a self-regulated profession? Then what are the statutory ethical regimes? Good character, requirement to practice law, one of the most important qualification after education. So first is education, that is must. You must have a law degree and all other important qualifications. Second is a person who has to practice law must be a person of good character. This is in itself a very important essentiality. Accountability. Can someone question you if you are not truthful to your client? What would be the consequences? So we will be studying that. Competence, how much quality of service one expects from a lawyer. Candor, admission, conduct, discipline. Unauthorized practice, what a lawyer can do, what a lawyer cannot do. Language rights, So whether a lawyer has to respect the language requirement of his client. Equity, diversity, inclusion. Whether a lawyer can discriminate on any grounds with anyone in regard to client representation. So we will be studying all these questions today. So I hope now you have gotten an idea about the syllabus. So this is basically the syllabus as it is the language. I am focusing on each single word so that you can get an idea about what we are going to study. The only thing that you need to have within yourself in order to pass this examination is your dedication to understand the concepts by heart. By heart means as and when, along with me, when I will be discussing the topics, just try to imagine this. Just feel that you are already a lawyer. So what you will do in this situation? Is this situation morally, ethically right for you? Is this what you feel? Whether particular conduct is uh, could be considered as a professional misconduct, then is profit making should be the purpose or there should be a balance. So just relate things with yourself, then you will find this subject super easy. So now first thing, professions and professionalism. The profession of law and law as a profession. What does word profession means? So firstly, the word profession has two things. One, we use this word for a particular person. A professional person is the one who has some expertise in some particular field, like we use medical profession, doctor, then we use law profession, so lawyer. So it means you have particular kind of expertise in that field. We never use business term for a doctor's profession. So this is the first difference. Second thing, whenever we talk about profession, be it teaching profession, be it lawyering, be it medical profession, ethical principles govern it. So side by side, your legal requirements demands you to perform ethically right. So morally right, what society expects from you. So professional by definition embodies dual commitment, one to their field of expertise, one you have to perform as per your field. Second, you have to perform as per ethical principles that govern your profession. So every profession has some ethics attached to it. What are ethics? So ethics as such are not any laws. They are the things that a person as per his or her own personal moral compass feels right or wrong. So what a person beyond law, beyond any written rules, feels that based upon your inner conscience, your inner calling, that whether a particular thing is right or wrong. So ethics are your inner calling. So as such, this inner calling word is not some defined term. When I was doing my post bachelorate, so we had a subject on ethics, and there in one of our class discussion a student used this word. So our teacher found this word really interesting. Even now when I am teaching, I think this is the best word to explain someone in simpler terms what is ethics. So it is your inner calling, what you think in a particular situation is right or wrong. At its core, professionalism encompasses a blend of education. So what else? So a profession has education, some kind of moral integrity, dedication to service. So these are all things that makes something a profession. So you have a degree, you have few moral integrity, you have few extra dedications for that service. Firstly, a profession is typically a member of recognized professional body, as I told you earlier, medical, education, lawyer, any kind of body. A distinction earned through attainment of specific educational qualification. So in order to be recognized as a professional, you should have some essential educational requirements, qualifications that are required to be done for that particular profession, for that particular field. However, this membership entails more than just academic credential. It signifies a pledge to adhere to a prescribed moral professional code of conduct which serves as the bedrock of their practice. So you might have heard about medical profession ethics, then teaching profession ethics. So usually there is a kind of a book ethics code which all the professionals have to follow. So it says that if in case there arises a situation where you think that you have to make a decision out of your professional educational qualification, your educational guidelines, then what helps you in taking that decision? So that is your moral ethical code of conduct. So here if we talk about lawyering thing, then again there comes many situations, I would say again many situations where you have to take a decision as a simple human being, out of the role of a lawyer. You have to make a decision whether you want to take up a case of a particular client or not. So sometimes we might have seen this thing in rape cases a lot. So in India especially, we have seen so many times that there comes a situation where someone has accepted, or it's evident that this person has done something heinously wrong. So kind of very barbaric, heinous crime. So usually what happens, few lawyers, they just say that we don't feel this is morally right, so we won't be representing this person. So the accused person. So these kind of situations come and you can take a decision based on your ethics. Similarly, if we talk about doctors' profession, when a patient is on ventilator, there the doctor who don't even want to take someone's life sometimes have to make a very tough decision. Even in case of euthanasia, so euthanasia also, like this kind of situation, the moral concept is much debatable these days, whether it's morally right to take someone's life or not. So this moral rights revolve around the doctor's role, questions doctor's profession. So it happens in every profession again, what we say, that your education plus your moral integrity both go hand in hand. So this is the basic idea about a profession. So next is, what is professionalism? Professionalism is your attitude, what you think about a particular conduct. So that is professionalism. Sometimes we usually call this term that okay, this person is not acting professionally if someone is rude to their client, if a doctor is not taking his patients effectively, patiently, or a lawyer unnecessarily just because he's getting some other good client who is ready to pay more money and things like that. So we usually use this term that okay, this person is not acting professionally. So that is not professionalism. This is not how you approach. Sometimes even in educational field also, even in our previous colleges, in once in a while we might have seen some professor, teacher, or even some student for that matter disrespecting their professor. So we usually use this term in a day-to-day life as well, that okay, this is not a professional behavior. So what is a professional behavior? So a professional behavior is that attitude that justifies your conduct. If you're doing something and that don't justify your conduct, it means you are making an unprofessional behavior. So an approach or attitude that embodies a justification for a particular course of conduct within a wider account of a morally defensible modus vivendi, mode of living, agree to disagree. It has a vital moral dimension that defines who lawyers are, what they aspire to be individually and collectively. So this definition has been given by Alan Hutchinson. So this important name you have to mention in exam as it is. So as per Alan Hutchinson, any approach, any attitude, any way of conduct that justifies that whether you agree to something or disagree to something has some moral justification behind it. That is a professionalism. What are the elements? What all things comes under professionalism? What all things together make professionalism? So your competence, where you stand, scholarship, integrity, honor, your leadership, independence, pride, spirit, enthusiasm, how strongly, how effectively, how impactively you are making your statement. It's not that always if you are disagreeing to someone, someone will say, okay, you are having an unprofessional behavior. No, it all depends upon how rational point you are making. Collegiality, civility, service to the public good, balanced commercialism. Next important topic is what is public interest? So public interest means what society seeks, what society expects. So from a lawyer, what do you think society expects? So very simply, not from only lawyer, but from the whole legal system, society expect the public interest is always in justice. So are we Sussex justices ex parte McCarthy? So in this case, it has been held that not only must justice be done, but it must also be seen to be done. People should see that okay, effectively justice has been done. So this principle of public interest underscores what it demands. It demands that importance of not only ensuring the fairness, impartiality, but also people should have a trust in our legal system, in our justice system. It's not just that you just show people that, okay, I have done something fairly, I have given a decision impartially. No, people should have trust, a strong trust in our justice system. So, upholding the welfare of society is another important principle under public interest. So public interest is the welfare or well-being of the general public society at large. So it basically depends upon how whole realm of law and governance work. It serves as a guiding principle, the public interest, for policymaker, lawmaker, legal practitioners alike directing their action toward the greater good of society. So what does public interest demand? Justice. What for what we do justice? We do justice for the greater good of society. So this is how you have to relate the concept so that things can get into your mind as a storyline. Imperative importance of public confidence in justice. So this thing has been emphasized, the public interest concept has been emphasized in the case of R versus Neil. So in this case, it was emphasized that public interest is the most important integral part of administration of justice. So if you want people public to have confidence in the legal system, then fairness, transparency, effectiveness, these three things are must. Now what is the role of lawyers and the profession in legal process in society? So firstly, a lawyer and client both have fiduciary relationship of trust. Fiduciary means trust. If someone is coming to you tomorrow with their case, with their issue, then what do you think the person is coming with? So the person is coming with hope, trust that you are going to save that person from the trouble in future. So fiduciary relationship is the basic ground on which this whole lawyer and client thing stays. So in legal profession, all lawyers are bound by fiduciary relationship with their client, which is built upon what I told you: trust, loyalty, hope, confidence. So this aspects underscore the lawyer's obligation to act in the best interest of their client and to prioritize their needs above anything else. So ethics is the cornerstone of legal practice. Occupies an important central position, as I told you earlier. From the beginning only, you must be thinking that I have been again and again talking about morals, ethics, because these are the guiding principles for a lawyer. So the whole professional conduct, decision making revolves around ethic. So upholding ethical standard ensure integrity of legal proceeding. It shows that a lawyer is fully dedicated towards his client, that a lawyer is working towards the ensurement of integrity in legal proceeding, and this ultimately maintain public trust, and this ultimately brings the concept of public interest. Next is self-regulation in Canadian legal profession. So when we talk about Canadian legal profession, it is a self-regulated profession. Lawyers are primarily responsible for regulating their own conduct. Basically, this autonomy is there in order to safeguard the independence of legal profession from the government influence or their domination. So what is the role of lawyer in society? So first thing, lawyers play a very important role in upholding justice because they are the main players, main actors who bring justice from court to a person's home. So this is a important concept. Lawyers play a crucial role in the preservation and regulation of society, ensuring the functioning of legal framework, upholding justice. As noted by legal scholars Joseph Raz and John Rawls, these two legal scholars have given their viewpoint on lawyers' role. What do they say? So they say law serves as cornerstone of social order, providing framework for governance and defining the basic structure within all activities that take place. So if you want public peace, if you want peace order in society, then whose role is it? So it is the law's role. So it's the law that maintain this public order. If a system, if a country, a nation has strong legal justice system, then obviously their people will be living at peace. There will be a good social order. Public will have trust in system. There will be impartiality, there will be transparency, the effectiveness, which are the three important principles under public interest. So all these things relate to each other. So these are the viewpoints of these two important scholars. Law as a business, law as a profession, what do you think? So one should understand the difference. So when we read the word business, so the first thing that you should understand is wherever you read word business, the word profit comes into picture. So when viewed through the lens of business, the law firms operate similarly to any other commercial entity offering services to clients in exchange of compensation. So when we talk about law business, so in which form you see legal business? So legal business in our society is in the form of law firms. So corporations, law firms. Business transactions are a common occurrence within law firm reflecting the economic realities of legal marketplace. So when now we have legal firms, this somehow reflects that our legal system has entered into a business marketplace. So acknowledging human dignity in legal practice. However, one should recognize that the practice of law transcends from commercial transactions. So what does this mean? This means that okay, it's important that few people are doing their business. So they are absolutely free to do that. No one is stopping them. But what should be the balanced approach? So balanced approach should be to acknowledge human dignity side by side. So it means that law firms, when they are charging good amount of money, when individuals are seeking legal assistance, they should maintain their dignity, humanity. So such reductionism means this profession to business thing. Profession as a lawyer to law firm a business thing should not just keep things monetary. It should overlook the human cost of legal issue and profound effect they have on individual lives. So law firms should maintain a balance between dignity and the cost they are charging from people. So law is a profession, it's an elite form of livelihood. Many people think that lawyers are the people who earn the most. So law as a profession is often regarded as independent self-regulating entity distinguished by its elevated status, specialized expertise. Unlike conventional businesses, the legal profession enjoys unique dominance. So there is no doubt that legal profession do enjoy unique dominance, but one should keep in our mind that the responsibility is also very, very high on lawyers. So this legal profession is driven by trust, confidence placed in the lawyer to uphold ethical standard and deliver justice. Maintaining integrity of legal profession, this is the main responsibility of a lawyer of this whole profession. So viewing law primarily as a business. So if we see only that, okay, lawyers are the rich people or law firms are making huge money, so this would not be a correct approach. This is diminishing the noble purpose, the sacred trust placed in lawyers to serve the justice and uphold rule of law. So balancing commercial viability with ethical responsibility is important if we want to fulfill our legal profession's important role of providing justice to the society. So the last line concludes this whole concept of law as a business in the form of law firm and law as a profession in the form of lawyers and what people think that is a elite form of livelihood. So balancing the commercial viability with ethical responsibility is essential in ensuring that the legal profession continues to fulfill its vital. So, as I have discussed this earlier as well, that okay, lawyers are dominant people, people go to lawyers, they have trust in the lawyers. Somehow, in this legal field, they are dominating also, but lawyer's responsibility is to maintain integrity. Lawyer is one such profession where cleverness has no place. You should follow ethical obligation, public trust should be maintained. Only then you can stand in the society. So responsible use of power. People do trust you. You have good power, but judicially, usage of power is of utmost importance. Then we have model code of conduct which guides the ethical principles, ethical conduct of a lawyer. So this code serves as a framework for ethical conduct. It focuses on lawyer's duty as how a lawyer has to uphold, protect the integrity of legal system. You might finding that okay, these things are repetitive. I am again and again talking about that similar thing just in little bit twisted form, but these are the syllabus requirements. You have to go through all these topics by heart, understand the concept, relate it to yourself, because in examination you will be expected to write these things only. So lawyer's duty toward clients is first is duty of loyalty, conflict avoidance, lawyer-client relationship. Most important thing is loyalty, trust, faith. So lawyer should prioritize client's interest above everything else. Lawyer must diligently effectively, smartly, intelligently avoid conflict of interest and maintain a commitment to their client's case. Then, commitment to excellence and public service. So, lawyers are called upon to continually strive for excellence, give their best, no matter what would be the result. That is a secondary thing, but give your best. Harmonizing responsibility as legal representatives. The responsibilities of lawyers and representatives of client, officer of legal system, public citizen are interconnected and complementary. So, as legal representative, lawyers are representing their clients. Number two, they are the officers of court. Number three, they are public citizen. So, all these three roles go side by side. Values. So, lawyers as morally neutral actors. What does these term means? Morally neutral actor. So, this means that it's not always that one person feels that a particular situation requires moral quality or moral intention, but situation is such that you have to take decision, you have to make important announcements based upon ethical considerations. So morally neutral actor is the one, that individual who does not inherently possess any moral qualities or intention, but such as an actor do by actions, by decisions, there shows some kind of morally guided reactions. So morally guided results. So this is what a lawyer usually does. So principle of neutrality, lawyers must maintain impartiality regarding the moral merits of their client's case or objective. Every individual harbors their own opinion, perspective, bias deeply ingrained in their subconscious. Consequently, achieving complete moral neutrality, separating law from morality and practice, possess a considerable challenge for lawyers, because every person has their own biases, own perspective, own opinions. It's not always that whatever your client is expecting, a lawyer feels the same. But ethical responsibilities of lawyers have always been a subject of debate, especially when it comes to loyalty to clients. So, what level of loyalty demands this profession? So, the lawyer profession demands complete loyalty and justice. So this tension is well illustrated by the contrasting views of loyalty and justice within the legal profession, ethical implications discussed by theorists as William Simon and David Lubin. So they have told that, okay, this is a never-ending concept, this is a never-ending debate. We cannot always say that, okay, a lawyer has to 100% follow the client's moral principles or moral expectations, but in reality, what happens? A lawyer has to be 100% truthful to few basic moral expectations, that are loyalty, honesty, justice, then candor. So these are the basic philosophical things that guides ethical lawyering. Now, for examination point of view, whenever you will be getting a scenario based question on ethical lawyering, three things that you will have to check one by one relating to the facts, that okay, in this particular case of A versus B, whether if the person A is in question, whether A has performed loyal advocacy. Number two, whether A acted as a moral agent. Number three, whether A has performed integrity well, whether A has performed the integrity, honesty, candor well, whether A has infringed any client-lawyer relationship. So all these three things will be analyzed under ethical lawyering. So what is loyal advocacy? Loyal advocacy means that you are adhering to ethical principles while advocating zealously for your client. It's okay, it's good that you are trying your best, you are giving your best to win case for your client, but You have to perform a loyal advocacy. Loyalty towards your profession, towards court, towards everything is of utmost importance. Again, it main thing that it imbibes is that it requires is loyal advocacy, that a lawyer should not take his or her client for granted. For his client who has chosen a person for legal representative, you should give your 100% diligently, competently, within bounds of law. Nothing illegal. You don't have to do anything illegal. Within the boundary of law, perform your duty, your advocacy with 100% loyalty. Give your best. So this is the concept of loyal advocacy. Then lawyer as moral agent. So lawyers not only act as legal representative but also as moral agent, as we have been studying from the very beginning of this lecture. So lawyers' duty is also to uphold justice, bring transparency and fairness in their action. Thirdly, integrity. So integrity is the cornerstone main thing under ethical lawyering, because integrity in itself imbibes so many other ethical moral concepts like honesty, transparency, then trust, confidence, so all these things. Canadian lawyers are obligated to practice law and discharge responsibilities honorably with integrity as outlined in Rule 2.1. This we read earlier as well. Then we also talked about the commentary which expanded the concept of integrity, so you can even refer to that as well. So conduct that reflects adversely on a lawyer's integrity, whether in private life, professional life, may warrant disciplinary action. So if a lawyer is not performing with integrity, then a disciplinary action could be taken against that lawyer. So now moving with our next topic, regulation of lawyer and regulation of law profession. Who regulates law profession? So in Canada, this profession is self-regulated, means the law societies, they primarily govern. So these societies are authorized. The power has been given by provincial and territorial legislatures, laws to oversee the legal profession in public interest. So these societies, these get their power, their authority from legislatures, few laws. So self-regulation means that a profession that is regulated by its own member. So if we are having lawyer profession as a self-regulated profession, it means that only law societies make rules and regulations. For lawyers, this means their professional conduct is controlled by rules created by their peers within the law society. So self-regulation means there is no outside interference, no government, no administrative interference, no ministerial interference. So this you have to keep in mind. So autonomous governing body, the law societies every province has. Specialized knowledge, lawyers must undergo extensive formal education, then practical training. Then admission is restricted in self-regulated professions. What does this mean? This means that only individuals who have competent qualifications are permitted to admit into this. So when we talk about this legal profession, that there is no outside interference, it is self-regulated, it is independent. So it means protection of individual rights and liberties there. So independence is important so that people's right, individual rights, freedom should be protected without any interference. Without any interference of whom? Government, state, bureaucrats. So justice should be delivered in its truest sense, and that can only be done if a particular legal profession is independent. Legal profession has historically developed independently of government control. That is why we are continuing doing that. So judiciary has always been an autonomic body. There is an important case of Canada Attorney General versus Law Society British Columbia. The Supreme Court of Canada affirmed the necessity of legal profession regulating itself independently to ensure the delivery of unbiased. So Supreme Court of Canada says that if we want to deliver unbiased legal services, particularly in areas like public and criminal law, then it is important that this profession should be self-regulated. So independence of bar from state is an all-pervasive manifestation, one of the hallmark of free society. Regulation of these members of law profession by state must, so far by human ingenuity, can be so designed be free from state interference in political sense. So in what sense we are saying free? Only in political sense. Federal of Law Societies of Canada has introduced rules to combat money laundering, including prohibited lawyers from accepting large amount of cash from clients or third parties, implementing new record keeping requirements regarding cash transactions. So this means that there are checks. So if government is not checking, who is checking? The law society. So law society in itself is such a great and excellent working authority body which is time and again making changes in its own rule so that the legal sanctity, the pureness, the independence of this profession can never be questioned by anyone outside. So, in order that the lawyers should perform their duties ethically, morally well, now anti-money laundering regulations has also been introduced by FLSC. Now, arguments for self-regulation. Some says that lawyers possess necessary education experience to understand the complexity involved in regulating legal profession, their expertise in their field, so they don't need any other oversee. They can oversee their own conduct. Also, self-regulation is more efficient, cost-effective with administrative and enforcement costs covered by the members of legal profession rather than by any taxpayer in the whole nation. Now, what kind of education is required if you want to enter into legal profession? So, to practice law in a provincial territorial jurisdiction Canada, individuals must be admitted to law society of their jurisdiction in whatever province they are residing. This admission process involves fulfilling pre-admission requirement plus good character. So there are two important qualifications: education and good character. So good character in itself is considered as a proper qualification. So in academic education, you must have a degree, then practical training, as we know, articling, bar exam, then professional whether a particular conduct is good character or not. So we have few such cases related to good character in which the number one case that is one of the most important landmark case is Pereira versus Law Society of Upper Canada 2000. So in this case, what happened? From 1994 to 1998, an applicant falsified his credential in order to secure articling position. So in 2000, that applicant applied for admission to Ontario Bar. Hearing aimed to determine if the applicant was of good conduct given his past action, whether he had reformed his character by the time of application. So for example, tomorrow if you are applying for articling position, you mention some fake experience for 4 years as a legal assistant somewhere. So now this is 100% a bad character thing. So whether the applicant had demonstrated good character in this case. So in this case, the hearing panel has made different determination, observation. So number one, what is a good character? So the definition is evolving, still rising. It is not exclusive. There is no clear-cut definition, but what are the things that we look into when we have to decide whether a particular conduct is of good character or not? Number one, integrity, honesty, truthfulness, candor, empathy, amalgam of all these. So a blend of all these. Proof lies on the applicant to show that good character at the time of application. Standard of proof is balance of probability. Being a lawyer is considered a privilege, not a right. A person should not be given this position lightly. A person has to prove that, okay, I am a person of good character and I deserve to be a lawyer. Transitioning to good character is a process, not a single event. It is not guaranteed that someone with a past lack of good character will become a good character. Outcome, result. So here the applicant failed to prove on balance of probability that he was of good character at the time of his application. So consequently, his application for articling and everything further was rejected. So another case, Law Society of Upper Canada versus Burgess 2006. So there was an issue of plagiarism during her time at the University of Toronto. So applicant lied to Law Society about issue of plagiarism. Question is whether applicant demonstrated good character by this lying to bar for admission. So panel hold that the applicant did not prove on the balance of probability that she was of good character at the time of hearing. So plagiarism, copying someone else's material, 100% shows demonstrate bad character. That is why whenever a tutor, even NCA tutor, even I make notes, make content, video lecture, again and again I urge students to not share further without permission, because this is a bad character. If someone tomorrow says this to bar, then your bar membership can definitely be rejected. So there should be a question, because these things at the very starting. So here, as you can see, even in her university examination, there was an issue of plagiarism, but that thing came up later during her admission to law society. Providing. So duty of candor. What does the word candor means? So simply it means frankness, the quality of being open and honest with your client specifically. So candor word you should understand, keep in mind frank. So now I think most of the things have already been clear when I told you the English meaning. So lawyers must be honest, candid when advising client, inform client of all relevant information, provide competent, candid opinion on merits and probable outcome. So there was a case of Strother. Lawyer failed to disclose financial interest in a potential competitor. So BC Court of Appeal upheld the finding of professional misconduct for not advising the client to reconsider previous legal advice. So there was another case of McCurcher. Lawyer failed to inform CN about existing retainer with another client. So there was an already ongoing agreement retainer with another client. So there is a duty of candor, frankness, openness that require duty of loyalty along with avoiding conflict and commitment to client's cause. So then Law Society of Alberta versus Schuster. Lawyer failed to inform the client of $3 lakh error in depositing fund. So Alberta Court of Appeal upheld the finding that error should have been disclosed. So next is what about language right? So Model Code of Professional Conduct outlines specific rules, commentaries which govern the language rights of client, ensuring their rights are respected, protected in legal proceeding. So what are these rules? So rule number 3.22a and 2b, they say that it is the duty of a lawyer that whenever a lawyer find appropriate, required, advise a client of client's language right. That in some cases a client might feel nervous or whatever. So it's the duty of lawyer to make sure that his client knows that the client is having a right to proceed in the official language of client's choice. So if a client wishes to retain a lawyer for representation in the official language of client's choice, a lawyer must not undertake the matter unless that lawyer is competent to provide services in that language. For example, I am a lawyer. I only know two languages, English and French. There is a client who wants me to represent in Chinese. So here, if even if I have like basic Chinese knowledge, but I am not 100% competent, or I cannot conversate properly, or I cannot put forth the advocacy properly before the court in Chinese language, then I should refrain myself. I should straight away tell client that okay, sorry, you have to find some other representation for yourself, because I am not competent enough to take further the proceeding in the language that you are requiring me to take up. So here you should not think about profit motive that okay, the client fees will go or something like that. This is the main rule that you have to follow. Firstly, number one, advise a client that the client has language right and they can proceed in their official language. Secondly, if the client requires you to represent in the official language and you are not competent enough, then you straight away tell the client and you must not undertake the matter further. So these rules commentary says that prompt advice. A lawyer should advise the client of the language right as soon as possible in the very early stages of the legal process. Then it would be the client's choice. The choice of official language is always solely individually completely of the client, not the lawyer. A lawyer cannot force a client to accept the fact that okay, I'm going to represent in this language only. Does not matter you want me to represent some other language. So lawyer cannot do that. So lawyer has to respect the language rights of the client because this is in consonance with Canadian Charter of Rights and Freedom section 19(1), then part 17 of Criminal Code, then provincial or territorial legislations. Many provincial territorial legislations provide additional language rights, including those related to aboriginal languages. So as I told you earlier that if as a lawyer you are ready to take the client's case in the demanded language, then before undertaking to represent the client in the language of client's choice, a lawyer must consider whether they can render service competently in that language. So this is in accordance with Rule 3.12 and its related commentary. Now there is a case which is related to language rights, Law Society of New Brunswick versus Ryan, 2003. So basically this emphasized the role of law society in maintaining a professional standard, protecting the public interest, reinforcing the need for lawyer to adhere to follow language rights as part of their duty. So language right, following language right is a part of a lawyer's. So that's all about today's lecture. I hope all concepts would have gotten clear. Even if you have any other doubt you want to enroll in this course, feel free to reach out on demystifycanadianlaw@gmail.com, or you can follow me on Instagram page Juris Journey NCA Triumph and Canadian Law. You can send me DM there. I will add you to a common WhatsApp group as well, where I usually send additional complimentary material from time and again, all the updates I share there. Also, please do subscribe to my channel. Keep supporting. Thank you and good luck.